So today I've decided to just cover some small parts. I'll do it in a few different clips of particular parts of the new BRBC form. Some things that are maybe giving me a little heartburn or need clarification, and maybe some practical things to think about when you're completing these. It's important to remember that the policy from the settlement, the NAR settlement, was very, very vague and did not cover all the considerations that are covered in the CAR form. So in other words, the things that were required per the settlement was that, you include a statement that MLS participants may not receive compensation from any source that exceeds the amount of rate agreed to with the buyer, that you disclose in conspicuous language that broker commissions are not set by law and fully negotiable, and include any provisions required by law. That didn't give a lot of clarity, and I know that there's been some, in the legal forms, there's been some hashing out and complaint by the attorneys that settled the case that the CAR form is in violation of the settlement and that there's going to be further litigation, which is even more striking when you think that the operation, the way we used to do things in real estate, was actually memorialized in the California Civil Code, which gave buyers agents and buyers brokers the right to be a sub-agent of the seller, and was actually formalized by our legislature in the law. And here's this decision from another state that is turning everything upside down and could be frustrating. So in the next couple, I think we'll go over, what they did address, what they didn't address, and particularly some thoughts about what you may want to think about when you're completing this form. I want to debunk one thing. There's one thing I'm certain of, is that no one can be certain about how this is going to work. And one of the fallacies you'll find online, and you'll hear people say out loud that you're not going to hear me say ever, is that something is a best practice. Best practice implies that there's a practice. There's no practice. I mean, this thing is upon us. It's less than 30 days old. We have no idea how the court will respond to this. We have no idea how the plaintiff's counsel will respond to these forms. There is no practice. There is no best practice. Whichever practice you wish to put into place, you can look at the beginning. I read to you the stipulations of the settlement. That's all they gave us to go on. So the concept that, just do this properly and you're in the clear, I don't have that same level of confidence. So we'll get into a couple of these in the next few clips. So step one, really step one. Who are the parties to this agreement? And we're talking about, the BRBC form, the latest release one. Who are the parties to this agreement? Well, the party is the brokerage and the buyer. And that's something that's really important, and I think something that's been lost in a lot of the seminars and the training that I've been party to, is that the broker is the party. So what are real estate agents? Well, they're licensed real estate salespersons, right? And they act as agents of the broker. So this agreement between the brokerage and the buyer, what place do the agents play in that? And to the extent that, let's say you chose exclusive, the exclusivity is not between the agent and the buyer, but the brokerage and the buyer. And that's really important, especially when you look beyond the agreement and you start thinking about fiduciary duties. And this is something that's been well lost in practice in the last 5-6 years, is the fiduciary duties the buyer's broker owes to the buyer. And that's one good thing about this form, is that it brings us back centered on some of the things that have to be done, some of the things that the buyer's broker owes to the buyer. I'll give you a few of them. One of them is the duty of loyalty in good faith. That's most cited as Birch v. Argus Properties. Then the duty to be honest and truthful, which is most cited by Ward v. Taggart, California case there. The duty to investigate and disclose material facts that might affect the principal's decision. Here's something that didn't appear in any of the previous paperwork we were doing when we created agency relationships between buyers and brokers. And it's something that came to the forefront here of this document. If you look at it here, and those are serious duties. I mean, when we talk about litigation against a broker, almost always in this office, you're most likely looking at a buyer broker, not a seller broker. Because the buyer broker has the duty to investigate. And if you read that Century 21 decision that's always cited when a buyer broker gets sued, that duty extends to even investigating permits and other matters that affect the property that are not, readily knowable by a buyer, and that the broker has to assess each buyer based on their experience, knowledge, and their abilities, because the buyer's broker is the fiduciary for the buyer. And in this agreement here, it talks about those pretty exclusively. It talks about broker involvement. It talks about, performing a market analysis. When was the last time a buyer broker performed a market analysis for a buyer? It talks about some of the people that are going to get introduced and the advisory rules that they're going to have to provide. For instance, it says in Section 8, broker authorizations and obligations, broker agrees to exercise reasonable effort and due diligence to achieve the purposes of this agreement. Broker will assist buyer by, and it gives you 4. I'm not going to bore you and read these to you. When was the last time as a buyer's agent we did these things? Seriously did these things. For instance, upon request, providing buyer with a list of professionals who perform the services described in the attached buyer's investigation advisory, provided broker has a referral list for such requested services. Not just, hey, call John. That's not enough. What do we know about John? How does John perform? Is John the only person we're going to recommend? Order reports and investigations, and schedule and attend meetings and appointments with professionals chosen by buyer. When was the last time we did that as buyer's agents? Now, there's some people watch and say, man, I do it all the time, Dave. I do it every single time. But I think that if we're being honest, there's a lot of times that that's not happening. And to the extent that's not happening, that's part and parcel with buying properties that have unpermitted porches, the roof caving in because we didn't inspect the property, so on and so forth. So it's interesting it's in here. It's tying that right to commission to doing those things that are so important for a buyer. This is the largest purchase most people will make. This is making sure that their real estate professional is advising them as to all the reasons why they should or should not make an offer on a house. And so before I get into even when do you have to execute this and should you do exclusive or not exclusive, I think taking a minute, sitting down, thinking about how your process is going to work with respect to Section 8, maybe something we forgot to do a long time ago, and understand those against the case law, the most likely ways to get litigated against, I think it's worthwhile to know that that's in the form, especially if you're going to be using this form. You're not creating another form, broker's not creating another form for agents to be using. So that's kind of the first consideration that jumped off the page. Okay. So something that's coming across my desk a lot, and probably the hot button issue I'm finding is in Section 8.2, type of representation, right? Is it going to be non-exclusive? Are we going to name the properties that we're going to show and just be bound to giving those fiduciary duties and representing the buyer as to those properties? Or is it going to be exclusive? And there's a lot of considerations. I don't have the answer for you, which one to choose. But I hope that there are discussions happening inside of the brokerage offices on how agents, licensed real estate salespersons of buyers are going to work together to fulfill the fiduciary obligations of the broker if we decide that we're going to be a brokerage that wants to do exclusive. Because that's a lot more responsibility, especially when we're talking about non-availability, right? I'm not here to suggest that if you're going to represent buyers that you should have to work 7 days a week, 24 hours a day. However, the fiduciary duties would imply that you have to do market analysis and locate properties in the best interest of the buyer. And if we talk an exclusive and a property is missed or not shown because of unavailability, what's going to happen? Is that going to be a breach? And especially, is it going to be a compensable claim if that buyer later buys a property within maybe the same subdivision, maybe the same property in a tract subdivision for more money because there was not availability of the real estate salesperson. And now the broker is going to bear that liability because it was an exclusive representation for an area. That's something that gives me heartburn because we're not used to that. We're not used to that. The custom is show the properties, deliver the offers, and be a fiduciary with respect to the properties which your buyer is going to purchase, right? And to the extent now we're talking about representing a buyer as an agent for a large area of space and representing the interest of that buyer as a potential homeowner. Those fiduciary duties, especially, the duties to be diligent, they get expansive. So that's something to think about. I know it seems kind of, I don't want to say sexy, but it seems attractive to go exclusive and make sure that you're going to get that commish. But the flip side of that is, what about church on Sunday, the long planned trip? Where's the coverage? Where's the coverage going to come in? Because it's not going to just be with respect to transactions that are in escrow on a particular property. It's also going to be with respect to potential properties that the buyer could have made an offer on or was pre-qualified to do so. So choose wisely on that. Maybe it is advisable to limit it to the properties you're going to show. And by the way, everyone knows, you guys have been trained on this. You're going to have these filled out before you do a virtual tour or a physical tour of a property. But perhaps you want to do this each time you locate a particular property and limit those fiduciary duties to those properties. I can't tell you what to do. I'm just asking that the people that come see me, that they're realistic about what level of responsibility they want to take with respect to buyers and what time commitment they realistically can give. So when you're looking at A2, I think that is more important than how you fill the form out and you got to check the box on the other page. I get all that. Is that something that the broker really wants their sub-agents to be doing? So that's something to consider. As we parcel through this, and I think it's important if you have watched any of these clips, or if this is the only one you're going to watch, I'm not here to bore you and go back through this. You've been through this training. The brokers have been through this. The car attorneys are defending this document, saying that they've complied with the NAR settlement. That's not my place. My place is to have you think about maybe what the terms actually mean and how they might be applied in this case law in the future, so that, knowing which boxes to check, you got it down. I'm just kind of giving you some color as to what I think these provisions could mean. And remember, there's no best practices. I don't know either. I have no idea how a court is going to look at these provisions. And if anyone else tells you they do, they're lying, because it hasn't been decided. So another thing, I'm just going to show you this real quick. This is a huge hole in the document. I've read it a number of times, and by the way, email me, click on my thing and send me a message thing, and we'll get back to you if you can figure this one out, because I can't figure it out. Okay, there's a right in here, a continued right to payment for broker-involved properties, and they go in great detail about what constitutes broker involvement. But here's the issue I found with this, and perhaps your brokerage will want to deal with this or figure out an addendum to fix this problem, but it's glaring. It says the continuation period here in E3 shall be blank calendar days after the representation period or any extension, continuation period. And that's a period, if you think about it, where if you look at representation period up here in A1, it says, hey, beginning on this date and ending on this date, or upon the completion of a resulting transaction, whatever occurs first, buyer broker is entitled to compensation. That's simple, right? It's from this date to this date. And that's the definition of representation period. Keep that in your mind. Representation period would be beginning on this date, ending on this date. The continuation period shall be blank calendar days after the representation period. Seems simple, right? I thought so until I read F. Cancellation. It says very clearly in a non-exclusive, and perhaps we're going to choose a non-exclusive, cancellation effective upon receipt or blank days after receipt. What that means in my mind is that if somebody sends you a written cancellation, then either the day you receive it or so many days after you receive it, your representation is terminated. Well, how does that apply to representation period? There's a glaring hole. Representation period should be defined by not just resulting transaction the date, but it also should have the termination or as canceled pursuant to section F. But it doesn't say that. So when does the continuation period run from? Is it the days after the date of cancellation, or is it the days after the representation period as defined above? If you're working on a file for 5 days and your representation period is for 2 months and you're terminated on the 5th day, does the continuation period start on that 5th day? Or does it continue for 2 months and let's say 30 calendar days after the representation period? That is a glaring contractual hole. This was put together in haste, there's no doubt. How's that going to be defined? I don't know. Hopefully the revision will deal with that. But there is a clear hole in the document when it comes to whether the continuation period would run from the natural end of the representation period upon a cancellation, or if it would start running from the date of the cancellation. So deal with that how you will within the brokerage, but that is something I can definitely see is going to cause issues as we proceed. Here's the one the NAR attorneys are getting all the heartburn about, G2. So the car attorneys say there's nothing in that settlement that precludes sharing of commissions as long as they're disclosed. And the attorneys are just flipping out because their position was, hey, you can't have sellers and buyers colluding on what the commission will be. Well, I mean, they're not technically colluding if you have a commission agreement set up ahead of time. By the way, this just goes to show you why that case was so poorly decided. The concept that buyers have ever paid commission is just outright outlandish. I think if you're in the real estate profession and you're around real estate agents, they would agree that when they go in for a listing appointment, that the seller would tell them, hey, show me what I'm going to net after I sell my house. And I think they'd also agree that sellers don't set the sale price based on the commission as much as they set it on what they either think the market will bear or what the net of that transaction would be. That was the misconception of the court and why this case was so bad, because it presupposes that somehow transaction costs are going to come down because buyers are going to have to directly negotiate with their brokers for a commission. And it's just not going to be the case. So here, this is the one giving them all the heartburn. I think this is a hot button, is G2 is like, hey, we can't go the old California Civil Code way where the seller goes ahead and caps the commission that they're going to pay. Now the seller is going to have their contractual commission with the listing agent, and then they're going to have to figure out which buyer to accept based on how much commission they may get asked for on the other end of the deal. Nothing wrong with it because that commission discussion is happening in open between the fiduciary and their principal. It's an agent principal discussion, how much is going to be paid, even though, here we go, most of these are going to get paid by the seller anyway. right? So now, instead of the buyer not really knowing, possibly not knowing what the commission is going to be on a transaction, it's the seller, when they list, is not going to know what to expect as far as a commission, and they'll have to choose their offers accordingly. I'm not sure this holds up at all, but that you would have to check that the buyer does not have sufficient funds to pay the broker before you can ask them to pay. That seems to me that that's a breach of your duty of good faith and loyalty to be disclosing information about your buyer's ability to overpay as a part of an offer. So that's got trouble written all over it. But that's kind of where we're being instructed right now from the car attorneys is, hey, you either say they don't have sufficient funds, or you say they're paying their own fees. So, I mean, I guess there's a universe, right, where the buyer says, hey, I may have sufficient funds, but I'm not buying this house unless you pay my commissions. I mean, theoretically, there's nothing wrong with that as well. Let me know. Let me know how that works in practice. I don't know if any of you are going to try that, where you say, hey, I'm not going to. The buyer's not going to say they don't have sufficient funds. They're just not willing to pay their brokerage fees. So interesting, all interesting. So yeah, that's going to be something that I'll look forward to hearing from you guys about, especially in the upcoming months and as we get into the sell season next year too as well. So one last observation, take it for what you will. This concept of buyers subjected to more than one commission if there's multiple brokers on a deal, maybe there's a broker involved property with one broker, and then they don't like that broker, they don't effectively cancel it, they don't get past the representation period. We know that, we don't know when that ends based on what I stated earlier. And all of a sudden you have two brokers saying, hey, you owe me and you owe me. Maybe consider in those interviews with buyers before you execute the document is to try your hardest to get a list of excluded properties that they've been shown or by another broker, and which I think that's going to be an uncomfortable situation. I don't think that's a situation we want to put ourselves in as a buyer's broker where we sell a property where there's a second commission owed. I think maybe it's easier to have that conversation up front and say, look, tell me what's excluded. And then the form will give you some protection on the fiduciary duty side, something we talked about earlier. It gives you protection right here that if it's excluded, the broker's not obligated to assist the buyer in any way with respect to that property. So if you have two non-exclusive agreements, one because broker AB showed them 3 properties over here and broker CD showed them 3 properties over here, theoretically, they could be working 2 deals at once. And depending on which deal gets accepted and put into escrow, the broker that's not fortunate to have that one, they can do this and say, hey, that's your baby, you deal with it. So I think that might be something helpful when you're doing that initial interview with the clients. And hey, without belaboring you and keeping you on this video too long, let's have those conversations, right? I think that'll make it easier. I have gotten some feedback from some of the brokers I represent, some agents, that they're having a hard time getting these executed, especially when someone's like, just show me the property. Sitting down, making it a practice, saying it's the law, we have to go over some things before I show you the property. I think that is a good thing. I think that might slow this process, make it a more professional process, provide that respect back to brokers that, hey, you're not door openers. You're fiduciaries. You understand this market. You have a list of professionals you're going to recommend. You're going to manage the transaction. You're going to be available for appointments. I think those are things that you can explain in that opening interview, along with letting them have that safety to know that, hey, man, if you're represented in another property, we're just going to exclude it from this agreement. That way, I would never subject you to two separate sets of commission. So, I mean, end of the day, legalese be damned. That endures you to people as lifetime clients, in my opinion. So, something to consider.
you.